My name is Jacques Ziller. I'm a former professor of public law at the University of Pavia, Panthéon-Sorbonne, and also a former professor of EU law at the University of Pavia in Italy, now retired. My contribution to this volume of the ELPIS Law Review that is dedicated to my late colleague and friend Professor Art.º is about the challenges to the principle of protection of the environment enshrined in Article 37 of the Charter of Fundamental Rights of the European Union. This presentation is based on a study which I have prepared for the European Parliament Research Service and which has been published in January 2025 by the European Parliament. You can easily find it on the internet by putting my name and the word environment on your browser. Well, let us first look at the origins of environmental protection in the EU law. We have to go back 54 years. In July 1971, the Commission, with proposals which were presented by Commissioners Art.º Spinelli, who was responsible for industrial policy, research, and technological development, and the joint researcher, and by Commissioner Wilhelm Haferkamp, who was responsible for the energy and internal market. The Commission presented the first Commission communication on community policy on the environment on 22 July 1971, a communication which is very often ignored by literature on environmental law. This communication had been triggered by an initiative of the United Nations Economic and Social Council, which proposed in July 1968 to the UN General Assembly that it include in the agenda of its 23rd session an item which had to be entitled the human environment. This was done by the General Assembly on 3 December 68 with resolution ERES 1346, which contained the decision to convene a conference on this theme in 1972. So this resolution, I quote, further requests the Secretary General of the UN to call upon the competent governmental and non-governmental organizations to contribute to the report that it is requested the Secretary General to submit on this theme at its 1969 session, end of quote. So the origin is both much earlier than very often said, because usually one starts with the development of the EU environmental policy in 1972. The origin comes from the UN, and it is this communication of 22 July 1971. It's a particularly interesting document of 191 pages. It was, I quote, intended for transmission to the competent authorities and to the various economic and professional circles concerned in the member states and in the countries applying for accession, with a view to obtaining any useful comments and suggestions, end of quote. And I quote again, also forwarded for information to the European Parliament, the Council of Ministers, and the Economic and Social Committee, end of quote. So since this first communication, which sets the scene with a highly developed number of proposals, not all of them having already been implemented. Now, since this communication, the EU has developed a quantitatively and qualitatively very important arsenal of standards and regulations aimed at protecting the environment. Let's start with the level of primary law. It's with the Single European Act of 1986 that the treaties have consecrated what has become now the principle of environmental protection in a wording that has been further developed by the treaties of Maastricht of 1992 and of Amsterdam of 1997. Well, as you can see, those developments with the Treaty of Maastricht and the Treaty of Amsterdam have led to TFEU title. Sorry. Yes, it's now those developments are in Article 191 of the TFEU, which is probably one of the best written legal bases at the present time, both very detailed, but also not too stringent, contrary to many other legal bases which have been inserted in the treaties later on. As you can see, Union policy on the environment shall contribute to the following objectives. One, preserving, protecting, and improving the quality of environment. But what's interesting is also that it is an objective to protect human health and to protect prudent and rational utilization of natural resources, and to promote measures at the international level, etc. Just a parenthesis about the prudent and rational utilization of natural resources. Hardly anybody has noticed that in the European Coal and Steel Community Treaty of 1951, there was also a provision about the rational utilization of natural resources. Let's close this parenthesis. And still in Article 191, it is indicated that the policy shall aim at a high level of protection, that it is based on the precautionary principle, the principle that preventive action should be taken, and the principle that environmental dangers should, as a priority, be rectified at source, and that the polluter should pay. I'm sorry. And as you can see also, the Union shall take account of available scientific and technical data. Now, if we stop looking at the text, we have now to go to the Charter of Fundamental Rights, which, as you know, has been proclaimed by the presidents of the European Parliament, the Council and Commission on 7 December 2000, and have acquired status of primary law with the entry into force of the Treaty of Lisbon on 1st December 2009. The question then was solved whether the principle of protection of the environment is or not a principle of European law. If we go again to the text of the treaties, you can see now Article 37 of the Charter of Fundamental Rights, a high level of protection, of environmental protection, and the improvement of the quality of the environment must be integrated into the policies of the Union and ensured in accordance with the principle of sustainable development. This means that there is not in EU law a right to a clean environment as such, but a principle of environmental protection, which, as you certainly know, according to what is indicated both in the preamble of the Charter in Article 52, it's a principle which needs to be further developed by legislation and cannot be as such invoked with the courts. Now, if we stop looking at the text, let's go on and see how we are at the level of secondary legislation. Here again, I have to show you something which I have been looking at and which I wanted to share. Now, this is a document which you can find if you look on EURLEX, you know, the databases for European law. And you can see that if using the words environment, consumer, and health protection, we find 1,100 legal acts and 74 international agreement, which is enormous. Now, true, in the ULEX database, there's no hierarchy, and there are as well fundamental acts of basis acts and also delegated acts and also implementing acts, but there are also a lot of individual decisions. Nevertheless, the sheer number of EU law acts is quite impressive. Now, what we can say about this is that probably at the level of the EU, we have one of the, as I said, most developed arsenals of written law. As far as the case law is concerned, again, basing my research on the court's case law website and using the terms environmental protection without the word principle, as at 15 January of this year, there were no fewer than 692 judgments, 72 orders, and 2 opinions of the court, as well as 193 judgments of the General Court, all this covering a period which began on 25 June 1998, which means at the time of entry into force of the Single European Act. Now, it would be wrong to conclude from this abundance that case law is a fundamental source of EU law on environmental protection, as the case law often concerns issues of interpretation relating to one of the secondary legal acts I have been referring to. Indeed, the abundance of secondary legislation in the area of environmental protection inevitably gives rise to a large number of referrals for primary rules, actions for failure to fulfill obligations, and actions for annulment. What can I say about all this, both primary law, secondary law, and jurisprudence? Well, the abundance of primary legislation and secondary legislation designed to protect the environment makes the European Union a champion, a world champion of environmental protection, especially in the present day, where the United States of America are dismantling quite a part of their own legislation. Admittedly, many specific measures of EU law are criticized by the economic sectors upon which they have an impact. They are also criticized by the general public and some specialized academics, just as certain case law decisions are criticized by some academics for not being bold enough. However, these negative criticisms are offset by others which go in the opposite direction, which call for greater intervention by the European legislation and bolder case law from the CGA. In my opinion, this shows that a certain balance has been struck so far in terms of both regulation and case law, even if regulations have a number of inherent flaws, and in that they are often the result of compromises at EU level between the proponents of different positions and the representatives of sometimes conflicting interests, which also are different from one member state to the other. This being said, as is often the case with EU law, the Achilles heel of environmental law lies in its effective application, which depends essentially on the national, local, and intermediate authorities of the member states, and of course also on the producers concerned and the non-governmental organizations, of which there are many and which have often very different views. Some academics and a number of NGOs are advocating the establishment of a genuine right to nature protection, which would call for an amendment of the treaties and maybe also of the wording of the Charter, a right to nature protection, which sometimes goes so far as to call this right to be proclaimed to take precedence over other rights and principles, which is not the case in the rights of the Charter, by the way, and this is not my position. In terms of text, of written law. Certainly, certain elements that could contribute to strengthening the principle of nature protection require only marginal adaptation to primary law, such as the explicit recognition of the principle of non-regression, which has been set by the case law of the Court of Justice. This principle could be invoked by the case law of the CGAEU in matters of environmental protection, as it is already for the values of the Union. It would also be useful to include a reference in primary law to the right to information, which is already mandatory under the Aarhus Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, Convention of 25 June 1998, to which the EU is a party. However, such a change in primary law remains marginal and more of a symbolic nature, given the abundance of implementing measures and case law in this area. Of course, stronger action by the authorities in member states and the private sector would be necessary to guarantee the principle effectively. In particular, this would require the simplification of a number of secondary legislation texts at the cost of a slightly greater role of case law. Let's now turn back to the principle. Since the 1986 Single European Act, it has been established in positive law at primary level that environmental protection is based on the principles of preventive action, the correction as a priority of source, of environmental damage, and the polluter pays principle. Without the Treaty of Maastricht added the precautionary principle, and the Treaty of Amsterdam added the principle of sustainable development. Although neither primary law or the case law of the court used the expression rights to the environment, to nature, to water, to natural resources, to animals, it is clear that the protection of nature, natural resources, and animals is part of the principle of protection of environment, as is the protection of human health. To this must be added the principle of integration, which is enshrined in primary law and plays a particularly important role in secondary legislation and case law relating to environmental protection. Now, I would like to show you a very interesting book which is available on the internet, which is the research handbook on EU environmental law, which has been published 5 years ago, but remains extremely interesting, helpful, and with a lot of interesting perspective. Now, I would like to quote a longer quote of a chapter by Julia Bandi, which is entitled Principles of EU Environmental Law, including the objective of sustainable development. It's my quote is at pages 52, 53 of the book you can see on your screen. Now, what Bandi writes is, despite vagueness and certain limited influence on policy making and enforcement, principles and other forms of legal conceptual basis have an essential guidance role in the field of environmental law. In the EU legal system, writes Bandi, sustainable development as a general objective has acquired a prominent place in primary law. However, it is rather vague and difficult to apply in practice. The principle of prevention, writes further Bandi, and that of rectifying the pollution at source have more bite as they are concretized by a whole set of legal and administrative instruments, such as environmental impact assessment or the authorization procedures, while the precautionary principle is taken as a standalone, self-explanatory principle with a strong foundation in judicial practice. The polluter pays principle is relevant for liability, and it entails the internalization of externality. Bandi writes further, the mere fact that environmental principles are listed in primary law is of great value. In addition, The importance of the general European law principles for the field of EU environmental law should also be mentioned, which makes the picture even more colorful. EU legislation backed by the CGAO jurisprudence has already proved how these principles are manifested in the daily operationalization of EU and domestic environmental legislation, in many instances offering viable answers to difficult questions, sometimes even changing the general legal attitude, as it happens in connection with the precautionary principle. Principles, writes further Bandi, are of immense help in proper interpretation, but are not able to fill all the gaps of environmental law. Hence, it would be advisable, says Bandi, to formulate specific rules in the environmental regulatory instrument, as explained in connection with prevention, while leaving a margin of discretion for the daily implementation to meet the practical channels and offer national and EU authorities some room for maneuver in the implementation of environmental legislation. So far, Ben. Now, as I already referred to, the principle of nature protection has in EU a constitutional status. It is enshrined, I've already said, especially in Article 91 TFU in the Charter, but also in Articles 2 and 21 TU, as well as in Articles 11, 36, 1114, and 777 of the TFU. This all means that the institutions, bodies, offices, and agencies of the Union are the authorities, as well as the authorities of the member states, are obliged to apply it, in particular by adopting and implementing the relevant secondary legislation. However, the limits of judicial protection of the principle of environment are often procedural, which means that, as I said, there are not very many big judgments about principles of environmental law, which further develop the apparatus of law. The limits are the following. Firstly, actions may only be brought by natural persons who are legal persons with the capacity to bring proceedings, which is determined by the law of the member states in the case of natural persons, and which means essentially having reached the age of majority, as well as by the law of member states in the case of legal persons, subject cases where the CGA accepts that groups with legal personality may bring proceedings. Secondly, the CGEU does not have the power to issue injunctions to the institutions, bodies of business and agencies of the Union, unlike the courts of some member states. About this, a parenthesis needs to be made about the often discussed judgment of the European Court of Human Rights of 9 April 2024 in the so-called Old Swiss Ladies case, which has been widely commented in the media and even by political figures, most often by giving it a significance that it does not have. This being said, coming back to the EU, it is hardly possible to predict whether and to what extent the CGEU will be called upon to rule on similar appeals. According to me, the abundance of secondary EU legislation in climate change means that the reason of the European Court of Human Rights is very difficult to transpose in context of appeals to the CGEU. To conclude, in my view, there are four main challenges for the future in applying the principle of environmental protection. Firstly, the scope of the principle is likely to be diminished by the rise of climate skeptics in a number of important countries outside the European Union and among its member states. According to an article which was published 3 years ago in Le Monde, in France at the time, 43% of the people questioned discounted the role of human activity in the current warming trend. compared with 26% in Germany, 17% in Italy, 26% in Poland, 40% in Turkey, 37% in the United States at that time, 20% in Spain and South Africa, and only 9% in Mexico, who were thought that climate change was due to human activity. In my view, there's a particularly high risk, whatever one's position on the issue of climate change is, of throwing the baby out with the bathwater by forgetting, for instance, for example, that electrically powered motor vehicles considerably reduce microdust emissions, whatever the overall CO2 emissions balance if emissions from power stations are taken into account. A second challenge, which is particularly visible since the end of 2023, is the contradiction between interest of industry and agriculture and interest in the short term, which are interests in the short term, and environmental protection in the medium term. A third challenge concerns cases. As I already mentioned, the absence of provision of primary law, and above all, the second law of EU law, means that the case law of the CGAU consists essentially of casuistry concerning the interpretation and application of secondary legislation. This is not a criticism. I am among those who believe that nature protection is a matter for political decision by democratically elected legislators and democratically accountable executives, and that it is a disservice to the courts and tribunals to ask them to decide for them. Like medical remedies, legal remedies have side effects, some of which are undesirable. What was long referred to as government by the judges is now described as judicialization of public life, or sometimes the judicialization of politics. About this, there's a very interesting report by the French Senate published in March 2022, which underlines that probably the main reason why in many countries, also in France, there are more and more people who go to court about environmental protection is due to a lack of political decision. And that means that there's a space left vacant by the legislature, which has to be occupied by the courts because the people want it. Now, the fourth challenge does not relate specifically to environmental protection, but to EU law as a whole. The question of its effective application. This depends on the authorities of the member states and both local and national level, not to mention the intermediate level. Admittedly, the local level is best suited to understanding the specific features of the territory whose environment needs to be protected. But issues such as air or water pollution or the protection of migratory birds are by their very nature cross-border issues and reflexes of the not in my backyard type and are particularly detrimental to environmental protection. In order to conclude about this, for those of you who would be interested in what I have been dealing with in this talk, I want to again indicate that there is this study which I have published, which the European Parliament has published, which is in French, le principe de protection de l'environnement, une perspective de droit comparé Union européenne, and which is as part of a series of different reports on different countries, both in the EU and in EU member states and outside. With this, I am now concluding, and I hope to have given a contribution to the special volume of ELPIS in memory of Professor Rainer Arnold. Thank you and goodbye.